Welcome to the IP Blueprint with Xavier Hailey.
Hey everyone, welcome to an all-new episode of the IP Blueprint with Xavier Hailey. I'm your host, Mike Leon. Xavier here is a registered patent attorney with the USPTO, licensed out in New York, New Jersey, and Illinois, and he helps entrepreneurs, investors, and small business owners protect their brands and ideas through clear and practical guidelines on trademarks and patents. And in today's episode, we're going to be talking about the basics of trademarks and how to protect your brand name before it's too late. Xavier, it's good to see you. Before we dive into the actual trademarks part of this, could you share a little bit for our audience about your background, how you found your way into intellectual property law?
Thanks for having me, Mike. Certainly. So how did I find my way into intellectual property law? It actually starts back when I was an undergrad. In undergrad, I was studying to become a chemical engineer. In my third year, I came across a book called Rich Dad, Poor Dad by Robert Kiyosaki. It explained to me that if you want to build wealth in the United States or in general, you have to own your own business. That attracted me towards business. So as I started to finish up my engineering program, when I graduated, I knew I did not want to proceed forward to go get a PhD in chemical engineering, but I wanted to be closer to business. So I went through the process of thinking, what higher level degree can I acquire that allows me the skill sets? I thought about an MBA, and I said, MBA in engineering is a dime a dozen. I said, you know what? How about a JD? Knowing the laws could be very beneficial for operating a business. So I decided to go ahead and go to law school and got my JD. So with the background in chemical engineering, I knew that I would be great for patent law. However, I somehow fell into trademark law. So I actually do both of them, patent, trademarks, and copyrights, a whole gamut of IP. But that's essentially how everything occurred.
That's great to hear. And so let me ask you then, let's wander into the law. So when someone does start a business or they launch a product, what does a trademark actually protect?
There's a lot of misconceptions around what is a trademark. So a trademark is a source identifier in connection with the goods and services. If you were to see Coca-Cola for soft drink, you know that it came from a particular source, in this case, the Coca-Cola company. Or if you were to see Windex, you know it came from a particular source. Windex for windows clean, so you know it came from a particular source, such as S.C. Johnson. So the purpose of trademark is to protect your brand. So when you're in the marketplace, when other people are using a mark that's similar to yours, they're not able to use it because you can go after them legally. Without having that protection, people can get into the marketplace and essentially steal your market share. So they would use your brand or a mark that's similar with related goods and services, steal your market share, and your business will go down.
So Xavier, let me ask you, because many founders assume that if you use a name first, it means that they automatically own it, which is kind of what you just said. But that's not true. How true is that under US law?
That is totally not true. That's also another misconception. Having a name does not grant trademark rights. Trademark rights originate from the actual use of the trademark in the marketplace in connection with your goods and services. When you start using your trademark in the marketplace, your goods and services, and people start to identify you as the source, that's when you start establishing trademark rights. A lot of people believe that, hey, I just set up my LLC or a corporation, I have a trademark. That is not true. I can give you many examples of companies that have their company name and they have a whole bunch of brands underneath them. For example, I did mention S.C. Johnson previously, where they have Windex. You also have scrubbing bubbles and so forth. Coca-Cola has a whole variety of other products like Smart Water, Desante, and so forth. So there's many companies that actually have their company name, but not necessarily tied to their brand. So to recap, a trademark is a source identifier. So just having your company name does not establish rights. You actually have to be using your trademark in the marketplace in connection with those goods and services.
Xavier, before somebody files a trademark or even a patent, what kind of search or research would help them spot some potential conflicts early?
So I recommend that people do a search. So on the trademark side, search at least the USPTO, which stands for United States Patent and Trademark Office. The reason you should search that first is because when you file for a trademark application with the USPTO, the examining attorney actually reviews that database and make the determination. But in addition to that, you also have to search common law to see if there's any other rights out there that which may not be registered. So one of the things you're looking at is is your mark similar to another mark? And are the goods and services related? In other words, a likelihood confusion analysis. Now, on the patent side, you have to look at whether your invention idea is novel, non-obvious, and useful. So when you're doing the patent search, you're looking at whether or not your idea is novel, meaning that there's no invention idea that covers what you have that you're applying for. Not obvious means is that, hey, if a person that works in the field, ordinary skill in the field, they're going to combine one or two references such as patent applications, so forth, to come up with your invention idea. And useful is a very low bar. So useful just means that it's not illegal. So it has some type of benefit and cannot be a perpetual motion machine. But from the patent standpoint, you have to analyze everything through that lens before determining whether or not, hey, should I file this patent application? Because if you file it and you're aware of this information, you're going to be prohibited from obtaining the patent because it doesn't meet the patent requirements.
So Xavier, what's the difference between if I filed a trademark myself online versus working with an attorney like you who handles it professionally?
The main difference is if you file a trademark by yourself versus working with an attorney is the lack of experience and knowledge dealing with trademark law. Now, as a business owner, if you were to do it yourself, remember that, hey, you can file a trademark application, but if you make a mistake in terms of doing the research, not doing the proper research, you may get something called an office action, which is a letter from the United States Patent and Trademark Office saying, hey, there's an issue with your trademark application, and it may be difficult to overcome that issue. Prime example is the likelihood of confusion. So a client in the past, they came to me, I told them my prices for my services, I would have an entire trademark. They decided not to move forward with me, and they filed their own trademark application. About 6 months, 8 months later, they received a likelihood of confusion. They came back to me, and they hired me. I argued the office action, but wasn't able to overcome the refusal. So, however, we would have been able to identify that issue at the beginning for doing the proper research. So reviewing the trademark database to see if there's any potential marks that's similar to that mark and related goods and services. So in essence, one of the problems of doing it yourself is the lack of experience. Second is that it takes time away from running your business. That is a main thing to consider because the expertise, if you try to do something you've never done it before, you have to figure it out. And remember, trademark process is a legal process, which means is that you are actually communicating with an attorney, a licensed attorney who is examining your trademark application. You may have to make legal arguments, and making those legal arguments can be difficult if you're not used to doing it. In addition to that, you have to get evidence if it's a substantial office action, which can also be very difficult, and you have to present the evidence in the right way. So instead of doing it yourself, you can hire somebody who knows what they're doing and can easily get through the process.
And piggybacking on that, doesn't the application ask for things like classes and specimen, and those choices I'm sure affect whether an application gets approved or refused, right?
And yes, it does. Those are two issues that people have issues with when they do it themselves. So a class is USPTO has a classification system, how they classify all goods and services. So for example, if you were selling clothing, that'd be class 25. If we were providing software as a service, it'd be class 42. If you provided a downloadable app on your cell phone, it'd be class 9. So your goods and services, you have to describe it and pick the proper class. If you do not pick the proper class, it can lead to increase in the pricing because you may have goods and services in one class that you describe, but actually belongs in multiple classes. 2, in terms of another issue with specimen, there's a huge issue with identifying the proper specimen. A specimen is real life evidence in the marketplace of you using your mark. So one of the problems with people thinking, hey, can I use so I have an Instagram, can I just use the logo on Instagram for my specimen? No, you cannot. So one of the things I'm looking for when I'm reviewing a specimen is there are 3 criteria. First, is the trademark prominently being displayed and function as a trademark? If that is, so that's good. Secondly, is the trademark is there general descriptions of the goods and services being used in connection with the trademark? Lastly, how does the public avail themselves of the trademark? Meaning, how do they acquire the goods and services? So if the specimen contains all those 3 things, then yes, it will be accepted. If it does not, it will be rejected.
And are there other things that cause delays or rejections at the USPTO? And can you give more examples of how do you get the clients back on track when something is delayed or rejected?
One of the major things for delays and rejections comes down to office actions. So not doing the proper research at the beginning before the application is filed leads to those issues later on in the process. An example that I mentioned earlier was the person that filed their own trademark and got a likelihood of confusion. That would have been easily identified before the application was filed. So like, hey, there's an issue with this. I don't think you should file that. Now, after the application is filed, there's really nothing you can do if it's something that's crucial to the registration. There may be things you can quickly fix. For example, if you were to file an application and there's a word that has to be disclaimed, disclaiming meaning that, hey, we are not going to take that word out of the marketplace because that's a commonly used word. For example, if you were selling, hey, Mike, fantastic apples, and you were selling apples. So the word apple will be disclaimed because apples immediately describes what the good service you're providing.
So once a trademark is registered, what does the ongoing protection process look like? For example, like renewals or monitoring or even the enforcement part?
After you register a trademark, you have to track when your renewal deadlines are. The first renewal deadlines for trademark registered trademarks is between the 5th and 6th year. The second one is between the 9th and 10th year. Then every 10 years subsequently after that. If you do not renew your trademark within the right time, your trademark will be canceled. The registration will be canceled, which means you will not have federal protection. And you have to start the whole process all over again. And there could be a chance where if you were to start the process over, there's a mark that can prohibit you from registering your trademark. And I actually have seen this happen, and I have handled an opposition proceeding and resolved this, trying to get the person's trademark re-registered after it's been canceled. And on the enforcement side, so all IP, you have to enforce your rights. You have to police your own rights. Nobody's going to tell you that somebody's infringing your trademark, somebody infringing your patents, or somebody infringing your copyrights. So for the trademarks, you can hire a watch service that will actually scan the USPTO database to see what marks are being filed and tell you, hey, those marks are similar to your trademarks. But you have to police your own trademarks. On the enforcement side, in addition to that, if you were to identify a mark that's similar to your mark and has related goods and services, you start the process such as sending a cease and desist letter. If they did not respond, you can escalate it eventually to a lawsuit. A lawsuit can be before the federal courts if you have a registered trademarks. If they have an application pending with the United States Patent and Trademark Office and it hasn't passed the publication phase or it's in the publication phase, you may think about doing an opposition.
So Xavier, as we land the plane on this episode, for someone that's listening to this, they're just starting out, what's the main risk in waiting too long to protect a brand name?
The main risk of waiting too long to protect your brand name is that someone may file an application with a similar mark and related goods and services that you have, and that application may block you from obtaining trademark registration, trademark protection. So in that case, you want to hurry up and make sure that, hey, you identify your goods and services, what you're planning to provide in connection with your trademark, and get everything out of the way and start the process as early as possible. And secondly, you do not have to wait till you actually are in the marketplace to protect your goods and services, protect your trademark with the connection with the goods and services. There's something called intent to use application or intent to use basis, where if you have a bona fide intent before filing, you can file it and start the process. So later on in the process, you provide that evidence of actual use known as a specimen. So that way you don't have to sit there and wait and think like, oh, do I have to get this product launched? So if you are for certain what good service you are going to provide, you can also take that route.
It's good to know. Great info. Xavier, thank you for the time and insights on this. Truly appreciate it.
Thank you, Mike.
And that's it for today's episode of the IP Blueprint with Xavier Hailey. If you want to learn more about protecting your intellectual property, do me a favor, visit HaileyLawFirm.com today. Thank you to everybody for listening to this episode. Don't forget to like, subscribe, leave a review and comment, or share it with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.